check it, and like the whole time, they were like, you don't have enough, and I checked it, I'm like, I have enough.
Yeah, I remember when I did my last one, I was like, all right, this is the amount. It's not that, it takes that many. I submitted it, and nobody said anything.
I don't know how to, like, I can't give it to them in person right now, so what am I supposed to do? I've emailed them, and I'm like, do you want me to email everything?
That's what I did.
Get mine done in a clinic.
No response. I'm like, do you want me to just not give it one until you answer? Like, I'm not getting it.
I still haven't.
Well, I'm not done.
Are you doing the tax clinic?
Probably.
Yeah, that's an easy way to do it. It's like free.
When is it?
I can forward you.
I've done the stupid, like, in order to get certified to do it, I've gotten certified every semester and never gone to a single one. I know, I should. Especially if it's my first time, I really won't expect you to do that. I'll let people have done it for a couple times.
Normally people like jump in, like, oh, hi, this person, and then you're just like, okay, I'll go.
Yeah, I'll sit at the front desk and take people's names.
That's what I did. I got a lot of privilege.
Yeah, I gotta do that, and I gotta finish my upper level.
Oh, I did that.
I was gonna do it over winter break, but my Newport problem got released on the 18th.
Rip.
So, yeah, that was my winter break.
That's your winter break
Yeah.
gone.
And they were like, yeah, so are you going? Well, I'm not doing mine, but all I have to do is like write like 800 words. So I'm happy. I'm like, you were that though. You know? We've had like a lot.
I'm ready to pretty good stuff for my clinic semester.
Flipping on click.
I would not want to.
I'm trying to get that.
I got it.
Should have taken it with that.
Oh, yeah.
He does not care. Legit.
Clicking.
It's clicking. Let there be click.
I just was like, I thought I had more time right there.
Oh,
Where'd the
yeah.
time go?
Yeah.
But I thought I had more time. But they were. I just didn't remember. I was like, I'm gonna expand. But like, I'm supposed to submit it by a certain time, and I'm gonna check it, and I even submitted it.
Got it online version.
Oh, you use it?
Oh, yeah, it's the same. That's the same.
Is it due at a
I could probably find a way.
It only lets you print out 10%.
I can bring all the things. You just want to print out 10 pages at a time. I didn't get it from the one you.
No, but I think, oh, you didn't?
No, I took a different one. It gives you the whole book. But the whole book is watermarked.
Yeah, the one that, if you buy it off the website, it lets you get the whole book, but you can only print 10% of the book. That stops you, won't let you print everything.
You actually.
Unless if I can print off one.
She
was like, damn it.
There's probably a way where you can.
Oh, you can figure it out. Yeah, you can copy it.
I'm sure if you give me 2 hours.
I'm not.
I'll figure it out. I got one class from freshman year, the textbook, like the whole class, I just sent to them over email.
Jeez.
It was on like some really sketchy Russian website, but it was a PDF of the whole book.
Yeah.
Yeah, you think so? I don't think this is like an ideal taking. When I figure out, I will try and figure out how to finesse this, and I'll send you a copy.
Send it to Melissa.
Is Melissa in this class?
Yeah.
Why is she not here?
She lives in,
BFE.
I said it on this
no, no, she
Wi-Fi.
doesn't live there anymore.
She does.
I don't know why Jake allows you on my website.
Last time I checked, there was nothing inappropriate on the
Years. No, it's like
Unless you find the
it's on the East
Constitution
Coast.
to be
It's on the East
offensive.
Coast,
Yeah.
on the beach, like an hour from Daytona, like an hour south.
Yeah, probably 4 beers.
Yeah, somewhere around. Wherever he got a job.
Oh, okay. Yeah, it was the St. Louis County, I think, public defender's office, right? Yeah.
But she doesn't live there. She lives like 30 minutes. So I can't remember what her.
Probably the middle of nowhere. I'm from.
Oh, no, yeah. She said it didn't. Yeah. But
See,
it is what it is.
got 6 folks at home. Not bad, right? 7, 8, 9, 10, 11, 12, 13, 15, 16, 17 out of 36.
It's pretty good.
Not bad.
It's over 50%, right? No,
Really close, though.
just under.
Really close, yeah. So has the drop ad period ended?
Yes.
It has.
No, Friday.
Okay.
Friday.
All right. So it's not too late to do the right thing.
And get your friends.
So-
And get your friends to
If,
go.
I know what you think.
if we come to class in person, do we still need to sign the attendance sheet?
Yes,
on the website?
please. Please do so. Yeah, whether you're here on the YouTube, hello everybody, or you're here in person, be sure to go to flaconstitution.com because that's the online attendance sheet. So if you've signed that, then you're here. Raise your hand.
Internet
2 hands up. Yours was first.
Yeah, that was weird.
Did you just see that?
But I found the attendance sheet in my history, so I was able to.
Okay, yeah.
that was-
Yeah, I keep hearing that the your law school's Wi-Fi restricts what websites you can visit,
Yeah.
and my website is not allowed to be visited.
Yeah, that's
I-
weird.
As I was saying earlier, I don't think there's anything offensive on my website. It talks about Florida's Constitution. If you're offended by Florida's Constitution, then I guess flaconstitution.com is an offensive website. But other than that, I don't think there's anything offensive on there. Yes.
I got that email, they said that I didn't sign it in class. I signed it in class, but that's one of the reasons why I didn't play, but didn't say it.
Yeah, you were obviously here. We were talking after class.
Yeah, I
So
signed it.
I just.
I reported you as present, so rest assured you were present.
I went back in later, and when I saw the email, it's.
Yeah. And I was being impartial about that email. I sent the email to everybody who hadn't signed, so nothing personal.
Well, I went in, but it showed me that, and I did it in class,
Okay.
but when I saw it, when I got online, I was like, it showed me as though I didn't do it, so I was like, maybe there was a glitch that it didn't allow, it didn't, because I put it in class, but when I got home.
Well, if somebody erased your name, that was wrong. Do not erase other people's names, please. Yeah. So,
Oh, yeah, that could be.
right? That would really be
Think
evil.
about that.
Yeah. Get your.
It's a whole different version of
We don't want to do
getting
that.
someone to write your name down.
Well, thank you, and welcome back. Glad to see everybody back. If you don't mind, I'll rip this thing off my face. Lord willing, the
My-
coronavirus will soon be a thing of the past. Lord willing, folks will look back at history and see pictures of people with masks on their face and wonder why. That would be nice. That would be a great outcome. Let's hope for that outcome. Pray for that outcome. Speaking of praying, as I mentioned in my first class, I start every class with a prayer, and I want to thank each and every one of you for that. You know, there are places in this world where you simply can't gather and pray, or you can't gather in great numbers and pray. You know, faraway places such as San Francisco, Chicago, New York, Sacramento. Thankfully, here we still have that right, and Lord willing, those who've lost that right will soon get it back. So thank you for letting me exercise that right. And of course, when I pray, I'm praying about you and I'm praying for you. But as I mentioned, if you'd like, this part's up to you. I could be praying with you, and that part is entirely up to you. So with that said, I offer this prayer to you, and I offer it for you, and I offer it for your success here in law school. I offer it for your success in your studies of Florida's Constitution and in all your studies that you have this semester. And I offer this prayer in the name of the Father, and of the Son, and of the Holy Spirit. Amen. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. Hail Mary, full of grace, the Lord is with thee. Blessed art thou among women, and blessed is the fruit of thy womb, Jesus. Holy Mary, Mother of God, pray for us sinners, now and at the hour of our death. Amen. Remember, O most gracious Virgin Mary, that never was it known that anyone who fled to your protection, implored your help, or sought your intercession was left unaided. Inspired by that confidence, I fly unto you, O Virgin of Virgins, my mother. To you do I come, before you I stand, sinful and sorrowful. O Mother of the Word incarnate, despise not my petitions, but in your mercy hear and answer me. Make me a vessel of the Holy Spirit. Let me be effective in teaching this class. Let these students hear what they need to hear to succeed in their studies and to be successful lawyers. I ask this through Christ our Lord. Amen. In the name of the Father, the Son, Holy Spirit. Amen. All right, so welcome back. And of course, last class was our first class, which means we covered chapter 1. Today is our second class, so now we'll cover chapter 2. And this is a pattern you'll see repeating throughout the semester. And our third class will cover chapter 3, and our fourth class, chapter 4, and so on and so forth. So I hope this crazy numbering system of mine helps keep you organized. Now, did we learn anything last week? Why do states have constitutions? God, I spent 2 hours asking that question, but did I ever answer it? Why do states have constitutions? One hypothesis I put forth, and it was a hypothesis. I'm here to educate, not indoctrinate. You're free to disagree with my hypothesis. My hypothesis was that basic human need for subsidiarity was the truest answer of why state constitutions exist and persist in the modern era. Of course, there are different answers to that question, but that was one that I put forth, and I believe I made a pretty good case for my hypothesis. Of course, you are budding lawyers, you are future lawyers, you will be practicing law. And whether you're negotiating a transaction or arguing to a court, either way, in a sense, you'll have to make the case. So I laid that challenge down in our syllabus. We take this issue of subsidiarity, and I ask you to take that question to some part of our studies. Your graded essay will be 10% of your grade. The details are in the syllabus, and there are more details to follow. But keep in mind this, that theme runs throughout our semester. Keep it in the back of your mind. When your interest is sparked and you see a specific topic that we're talking about, and you think to yourself, this raises substantial issues of subsidiarity, that might mean that you found the right topic for your graded essay. So keep that in mind. I left you with a question, a cliffhanger, if you will. And I'm sure you've been dying all week to know, what is the answer to McGinley's cliffhanger? First, a reminder, the cliffhanger. I asked you, as a lawyer, how could you argue that the Supreme Court of the United States, that highest court in the land, the most high court of all our nation's high courts, how could you effectively argue to SCOTUS, the Supreme Court of the United States, that they lack jurisdiction to review an opinion of a state court or even a state's high court? And please understand the question. I'm not just saying, how could you argue to SCOTUS that they should not exercise their discretionary jurisdiction? No, I'm going further than that. I'm asking, how could you effectively argue that the Supreme Court of the United States lacks jurisdiction, that regardless of how they feel about taking or not taking the case, they are powerless to take the case? Lacking jurisdiction means lacking the power to preside over that matter. So how could you argue that? And was the question a setup? Could it possibly even be that the Supreme Court of the United States could literally lack jurisdiction, lack the power? Now, if you are a non-lawyer, if you never went to law school, you might erroneously believe, well, of course, the Supreme Court of the United States always has the power to review any case. But is that true? Not necessarily. We looked at the opinion of Michigan versus Long, and you studied it in great detail. What was the message? What was the takeaway insofar as that procedural question of being able to deny jurisdiction to the Supreme Court of the United States? You raised your hand. Talk to us.
The biggest takeaway is if you're going to argue adequate and independent state ground, you have to have state cases to make that argument.
I like it. Adequate and independent state ground. The Supreme Court of the United States lacks jurisdiction to review the decision of a state court or even the state's highest court that is based upon an adequate and independent state ground. An adequate and independent state ground. Let's take a closer look at this idea of an adequate and independent state ground. First, let's look at the vocabulary. What is meant by adequate? When we say that the opinion is adequate, what is the requirement? What is it that we're looking for to know whether or not the opinion is adequate? The state court opinion has to be based upon adequate and independent state grounds. The state grounds are adequate when they do not deny the full panoply of federal rights. The state ground is adequate if it does not deny the full panoply of federal constitutional rights. I've done my best to choose my words wisely. I didn't just say it's adequate if the state law doesn't deny those found within the text of the U.S. Constitution. The inadequacy might be a failure to provide those rights within the U.S. Code, the Code of Federal Regulations, the SCOTUS case law precedent interpreting either the text of the Constitution or the U.S. Code or the Code of Federal Regulations, perhaps even the penumbras formed by emanations, if such a thing even exists, of the federal Constitution. All these things constitute a full panoply of federal constitutional rights. The state ground is adequate so long as it does not deny any of the panoply of state constitutional rights. So there's a brief discussion of adequate. What is meant by independent? SCOTUS is only denied a jurisdiction by a state high court opinion that on its face contains an adequate and independent state law ground. When is the state law ground independent? Simply stated, it's when that state law ground arises from state law and state law alone. Independent, alone. To help illustrate that by example, what if we're looking at the face of a state's high court opinion? We're trying to determine whether or not it's based upon an adequate and independent state law ground. When we look at the face of the opinion, we see many citations to the U.S. Constitution, many citations to the U.S. Code, many citations to federal case law precedent, many citations to precedent from the Supreme Court of the United States. And we see interpretations of these federal sources. From what I've described so far, would that opinion on its face contain an adequate and independent state law basis? Well, certainly it may be adequate, but it would not be independent, because what I've described so far is an opinion that is dependent upon the panoply of federal rights. So there's an example of not being independent. Let's try to imagine a different high court opinion. In this different high court opinion, we see a citation to the plain language of the state's constitution. We see no other citations at all. That opinion, from what we know about it based on this hypothetical, appears to be able to satisfy the independent prong of being based upon and having a plain statement of an adequate and independent state law basis. And you can see by those two diametrically opposed examples what's meant by independent. The next question, who must conclude that on the face of this state high court opinion, there is an adequate and independent state law ground? Who must reach this conclusion? And remember, it is the Supreme Court of the United States jurisdiction that we're attempting to avoid. So whose opinion, whose statement, who has to conclude that the Supreme Court of the United States lacks jurisdiction? Yes?
SCOTUS themselves?
SCOTUS themselves. You are correct. Why? Why is that correct? Well, if you remember keeping score, where was our scorekeeper? Oh, there you are. Yes, it was a blowout, was it not? Yes, the state again and again fell to the primacy of federal law. Indeed, the supremacy clause, as it's called, of the U.S. Constitution is aptly named because it does make the federal Constitution and all the laws enacted pursuant to it primacy above state laws, even the state's constitution. And if you open the text of the U.S. Constitution, and you all confess to me you took a federal con law class where nobody ever did that, I understand. But the document does exist. There is a U.S. Constitution, and there are words on it, and you can read them. And if you open it and read the supremacy clause, you'll see specifically stated that it is supreme even over state constitutions. It's right there. And that's been interpreted to mean what it says. So yeah, that's who has to determine SCOTUS itself. So I got to get SCOTUS itself to say that SCOTUS lacks jurisdiction. Only SCOTUS's determination that SCOTUS lacks jurisdiction will result in SCOTUS lacking jurisdiction. That's correct. Where must I find this plain statement of an adequate and independent state law basis? Do I tear open the state law? Do I tear open the judge's notes from the state high court? Do I ask the state high court justices to come on down to SCOTUS and tell us what they meant? Where do I look to determine whether the face of a state opinion has an adequate and independent state law basis so plainly appearing on it that SCOTUS lacks jurisdiction? I look at one place, I look at one place alone. I look at the face of the state's high court opinion. That's it. I don't go further. And you notice in those portions of Michigan versus Long that I included in the text, there was that analysis of how prior to the 1983 decision in Michigan versus Long, SCOTUS had sometimes taken different approaches to determine whether on the face of the state's high court opinion there was a statement of an adequate and independent state law ground. But no more, said Michigan versus Long. Michigan versus Long says from now on, we don't remand to the state high court for clarification. We don't do anything other than look at the plain language of the face of the high court opinion from the state court to determine whether that opinion from that state court has an adequate and independent basis in state law. And we're looking on its face for a plain statement. Specifically, here's what we're looking for. If we see on the face of the state court opinion that plain statement, or I should say more specifically, if SCOTUS sees on the face of that state court opinion this plain statement of an adequate and independent state law basis, then and only then SCOTUS lacks jurisdiction. What if it's debatable? What if it's debatable? What if you're at oral argument in front of the Supreme Court of the United States? And of course, all of you soon will, right? But what if you're in oral argument before the Supreme Court of the United States and you say, well, Your Honor, I can see how it's debatable. Bad move if your argument was intended to deny SCOTUS its jurisdiction. Because the default, if you will, for you computer programmers out there, the default status is that SCOTUS has jurisdiction. So if it's debatable, if it's not clear, then SCOTUS may take jurisdiction. So it's got to be a plain statement. It's got to be found. It's got to be clear. It's got to be plain. Now, you've read many court opinions, enough to know that sometimes a court reaches one outcome for more than one reason. You've seen such opinions, right? The outcome is X, and the reason is this, but also the reason is that. You've seen such opinions. For such an opinion, must each reason have an adequate and independent state law basis in order for there to be a plain statement on the face of that opinion that will deny the Supreme Court of the United States jurisdiction? And the answer, interestingly, is no. If the opinion is alternatively based, then SCOTUS, and here's the quote from Michigan versus Long, of course will not undertake to review the decision. Of course. I like that. I didn't think it was so obvious to me. I wouldn't have screamed, of course. But it's nice to know. And we know it because there it is. That's an exact quote there in quotes. That's why I put the quote in quotes, because it's quote. That's a quote from Michigan versus Long. So if that one outcome was reached in more than one way, in other words, if the outcome was alternatively based, then as long as one of those alternatives has a plain statement on the face of the state court opinion of an adequate and independent state law basis, then of course SCOTUS lacks jurisdiction. So there was the cliffhanger. Began the class by saying I was here to empower you. With Michigan versus Long, I've just empowered you to correctly and effectively argue that the highest court in the land lacks jurisdiction. That's power, right? Stay with me. I have lots more power to impart upon you. But always remember, with great power comes great responsibility, right? So let's use our skills as lawyers to make the world a better place. So that wraps up chapter 1 with adding this one little nugget. I talked about in the notes and questions to consider, part of Michigan versus Long, the effect that that opinion had on state constitutional law jurisprudence. Within a year and a half or 2 years of that, pundits say we saw an explosion of state constitutional law jurisprudence. And why would that be? Because finally we had the path spelled out to us by SCOTUS's decision in Michigan versus Long as to how state courts could be the final arbiters of state law. You remember that quote from chapter 1 that we talked about in last week's lecture about that Supreme Court justice who opined, well, we're not final because we're infallible, but we are infallible because we're final, right? Supreme Court of the United States. You might disagree with its ruling, but to whom do we appeal in the court system if we don't like the outcome of the Supreme Court of the United States? There's nobody left, right? They're final. A proper use of Michigan versus Long, a use that proves the state's high court opinion has an adequate and independent state law basis, means that SCOTUS lacks jurisdiction, which means that the state high court becomes the final arbiter, which means that the state high court can make that same claim. Suddenly it is final, right? So in our federal system, we have to decide, when it comes to something like the plain text of a state constitution, who shall be the final arbiter of what the text of a state constitution means? Through Michigan versus Long, a state's high court can grasp that power. Remember that doctrine of subsidiarity, which had many facets, one of which was to respect the authority of lower sovereigns. This use of Michigan versus Long respects the authority of a state's high court and puts it within the state's high court power insofar as it's the state high court who drafts its own opinions. It puts it within the state high court's own power to be the final arbiter if its opinions, in the opinion of SCOTUS, have an adequate and independent state law basis plainly stated on the face of the opinion. So there is a way that a state's high court can be the final arbiter of what a state's constitution says. Yes?
Maybe I missed this when I was reading, but is there any time that if it's been interpreted one way that they say this is states only, and then SCOTUS comes in later and says, you know what, we're gonna review that ourselves.
Yeah.
They still have that ability, or is it once they make a decision that's states
Oh,
only?
of course they do. Of course they do. We've seen throughout history times where the Supreme Court of the United States has overruled prior precedent of the Supreme Court of the United States. So yes,
Well, I understand they do that, but I'm saying usually, is it gonna be more, like, even their own decisions, they hem and haw, they're like, okay, yeah, we did it this way, let's overturn it, but to me, it seems like their own decisions, it's easier for them to go away from, but once they've already made a decision on the state, like, this is your jurisdiction, are they a little more
no,
reluctant, or are they more?
they're no more constitutionally bound than in any other type of opinion. We'll discuss later in tonight's lecture the concept of stare decisis. Putting that aside for just a few moments, because that comes later in the lecture, we know that the Supreme Court of the United States throughout history, from time to time, has reversed decisions of the Supreme Court of the United States. We know that stare decisis, although exist and enshrined and powerful, can be overcome. For that reason, the state high court as final arbiter is a tenuous position indeed, because at any time, SCOTUS can overcome a prior favorable decision and intrude itself, indeed take over that area of state jurisprudence. And it happens. And it happens not just with SCOTUS. You remember the scoreboard. How else might I overcome an adequate and independent state law? Does it have to be in the text of the U.S. Constitution? No. You remember the scoreboard from our last lecture. It doesn't have to be in the text of the Constitution. It could be just a Supreme Court of the United States decision. Didn't have to be there. Could be one of the federal appellate circuit's decisions. Doesn't have to be there. Could be the United States Code, an act of Congress. Didn't have to be there. Could be the Code of Federal Regulations. Didn't have to be there. We talked about an agency head's decision. We talked about what's left of federal common law after Erie versus Tompkins. Any of these federal sources overcame a contrary, adequate and independent state law. Any of them. So yes, it's always a tenuous position for the state's high court to be in. But through a proper use of Michigan versus Long, they can occupy that tenuous position of being the final arbiter of state law. And how they write their opinions is critical. The text of the opinion, remember, was the thing that SCOTUS looked at to determine whether SCOTUS lacked jurisdiction. The law review article that we talk about in the notes and questions to consider of Michigan versus Long put state high court decisions into 3 arbitrary categories. And by doing so, gave us some adjectives by which we could describe the face of a high court decision. Obviously, if we're going to argue to SCOTUS that the face of the opinion has or does not have an adequate or independent state law basis, it might be nice to have some way to describe the face of that opinion. Agreed? Here, we don't have a statute, we don't have a law, but we have adjectives, ways to describe the face of the opinion. One way is that the opinion takes an approach of dual reliance, by which we mean perhaps the face of the opinion talks about a constitutional right, and perhaps in so doing, it talks about the U.S. Constitution and the state constitution. Many constitutional rights are referenced both in the federal constitution and the state constitution. Freedom of speech, freedom of religion, freedom of the press. Many rights appear in both. A state court opinion might talk about both. You might use the adjective dual reliance to describe such an opinion. Is it likely that such an opinion has an adequate and independent state law basis? It's not impossible, but it's probably suspect. It's not impossible, but it's probably less likely. But the state high court opinion need not be written in such a way. Another alternative to dual reliance is a primacy approach. And the very first case we talked about in chapter 1 took a primacy approach. It looked for rights of the criminally accused by looking first to the state's constitution. That opinion found adequate rights for the criminally accused Floridian in the Constitution of the state of Florida, and it stopped there. That was a primacy approach. Is it likely that that kind of opinion would have an adequate and independent state law basis? It's more likely, is it not? Because of the primacy approach. But there's two things to note. You still have to give the legal standard. You still have to analyze whether that was adequate and whether that was independent. Primacy makes it more likely to have been independent, but don't forget adequate, right? There are parts of our state constitution that are unconstitutional. Remember that lesson from chapter 1. For example, with its reference to sectarian, in other words, Catholic, our state constitution, like many other state constitutions, discriminates against me and my fellow Catholics by saying that we're not entitled for any state dollars to be used towards our education. Is that in the state's constitution? Yes, it is. Is that constitutional? Please God, I hope not. Clearly, in my opinion, it's discriminatory. Please don't discriminate against me because of my faith. But our state constitution, in my opinion, does that. So the question then, is it independent? Well, yeah, because you don't find that phrase in the federal constitution. The person who wrote it failed to get it passed by Congress as an amendment to the US Constitution, but succeeded in getting it passed in many states because that long dead congressman was running for president on a ticket of anti-Catholicism. So that anti-Catholic failed presidential candidate's legacy lives on in several state constitutions, our own included. So it's independent, it's in there, but is it adequate? Or instead, can we effectively argue that discriminating against me and my wife and my 11-year-old son, Patrick, and my 7-year-old daughter, Madeline, who all go to St. Margaret Mary Catholic School, that discriminate against us because of our faith is somehow unconstitutional? I hope you can make that argument. Certainly I would make it, and I believe I'm right. So the primacy approach, the first thing to note about it is that it increases the likelihood of passing the adequate and independent standard because the independence is there. But you still got to check for the adequacy. Another thing to note about the primacy approach is, what if we find the answer in the state constitution by taking the primacy approach, and then later we conclude or we analyze some federal sources? Does that necessarily mean we're going to fail the adequate and independent state law based test? And the answer is no, not necessarily. Of course, the more federal references we see in the opinion, the stronger the argument can be made that it's not independent. But it is the result, it is the outcome. Remember, sometimes an opinion will reach one outcome for more than one reason. If the opinion says, using a primacy approach, that this law is a violation of the state constitutional right of free exercise of religion, and then after so concluding goes on to opine that it's also a violation of the federal constitutional right of the free exercise of religion, that would be two reasons for the same result. And remember, for those types of opinion, we only needed one path to the outcome to pass the Michigan versus Long adequate and independent state law basis test. Remember that. Another way we might write an opinion, different from dual reliance, different from primacy, is supplemental. Here we would turn first and foremost to federal law, such as the federal Constitution. We would get an answer, and then, assuming we had an answer, we would go on to also analyze state sources, such as the state Constitution. Can that pass the adequate and independent state law basis? And it could, but it looks less likely to be independent. Would you not agree? Of course, it might be one of those instances that we talked about over here. It might turn out to be alternatively based by using the supplemental approach. So you have to do that analysis to see if it's alternatively based. But there are three different ways, according to the scholars, how state courts have been writing opinions after Michigan versus Long. But the takeaway from this law review article is that these are adjectives. Things such as dual reliance, primacy, supplemental are not rules of law. They are descriptors. They describe the face of the opinion. The question to be answered is whether there's a plain statement on the face of the opinion of an adequate and independent state law basis. That is the legal standard. So I leave you now and leave chapter 1 with this question. If you were a lawyer staring at the face of a high court's opinion, deciding a constitutional issue, could you make the argument for and against the U.S. Constitution? For and against the U.S. Supreme Court taking certiorari jurisdiction to review the high court's opinion? In other words, did I keep my promise? Have I empowered you to do what I promised I would empower you to do? Do you know how to do that? Is that something you can do? To help you answer the question for yourself, I give you this very brief summary, and a summary is just that. Details are missing from a summary. Summaries don't have all the details. But to summarize the answer to that question, you want to argue that SCOTUS can and cannot? You want to argue that SCOTUS should or should not? Can or cannot is a question of jurisdiction, and the rule of law was from Michigan versus Long. The rule of law was whether on the face of the opinion there is a plain statement of an adequate and independent state law basis. In doing that analysis and applying that rule of law, you might turn to the scholars' three modes of analysis. You might use those adjectives we talked about of dual reliance, primacy, or supplemental. And this tells us whether SCOTUS can or cannot. But you can also argue either for or against certiorari jurisdiction of the Supreme Court of the United States by arguing whether it should or should not take jurisdiction. Because just because SCOTUS has jurisdiction doesn't mean SCOTUS has to exercise that jurisdiction. You might, as a fallback, argue that they shouldn't take the case, even though they can. And indeed, you might have no other choice. It may be so clear that they can take the case that all you have are these policy arguments to make to the Supreme Court of the United States. Policy issues in favor of consistent human rights. We talked about state constitutions granting nothing less than the full panoply. Can't crash through the floor, right? The full panoply of federal rights are that floor, that bare minimum. But we talk about state constitutions without denying any of the full panoply of federal constitutional rights might grant even more and higher rights. You might argue, should that be? If these are basic fundamental human rights, if these are rights of a citizen, should it matter which state the citizen is in? You might argue from a policy standpoint that it shouldn't or couldn't matter. On the flip side, you might make the opposite argument. You might make arguments in favor of state sovereignty. You might argue that that's how our federal system is contemplated, that each state can be a laboratory of democracy, you might argue, where each state, without denying the full panoply of federal constitutional rights and federal statutory rights, might experiment with granting even greater rights to its citizen. And through that experimentation, might be able to lead the way and show the rest of our nation the benefits of an expanded right. So those are the policy arguments you might fall back upon or might be forced to fall back upon when it comes to arguing for or against the petition for writ of certiorari to the Supreme Court of the United States. And that's how I'll end our discussion of Chapter 1. Any Chapter 1 questions before I dive into Chapter 2? As you take a cursory look at Chapter 2, you see a format somewhat similar to that in Chapter 3. I begin with an analysis of ethics, and I then launch into a list of rules that apply. This is the bare bones structural description of both my Chapter 2 and my Chapter 3. And as we look at chapter 2, we look at the topic of constitutional construction. Join me on chapter 2 so that we can all be on the same page. As we look at chapter 2, I'll ask you this question. And the question goes like this. Assume that a proper use of Michigan versus Long empowers a state's high court to issue rulings over which the U.S. Supreme Court lacks jurisdiction to review. Assuming that to be the case, then without the safeguard of U.S. Supreme Court review, what restrains state high courts? And that's a serious question, is it not? If you become what that one Supreme Court justice I was quoting last lecture said, if you become infallible because you're final, then with that power comes great responsibility, does it not? And how can we restrain that responsibility? All our faith backgrounds are different. All our beliefs are different. Personally, I'm a sinner in need of a savior because I'm a fallen creature. I was born of original sin, and I'm constantly tempted to sin again. And I'd love to tell you that today was a great day where I didn't sin against anyone. But if I was honest with myself, I couldn't make such a statement. Perhaps I'm not alone in being described that way. Perhaps that's also true of lawyers. Perhaps that's also true of judges. Perhaps that's also true of groups of judges. Perhaps that's also true of the state's high court judges. So if we're going to make each state high court infallible because they're final, what restraints have we put upon these mere humans? These, if you will, fallen creatures? What restraints are there? That's a serious question, is it not? So what do we have? We have one possible answer, and that's the ethics. The ethics of the judges and the principle of judicial restraint could prevent abuse and safeguard against possible improper interpretations of the state's constitution. But are these safeguards sufficient? And that's how I open chapter 2. I look at that and I quote from Webster and Bell's law review article about first principles of constitutional revision, where they say over the years, scholars and courts have applied a wide range of methods for analyzing constitutions, have they not? One of them they talked about was a textualist, right? Some SCOTUS judges might be referred to as a textualist. And what's that? That's deriving the meaning of the Constitution from the pure and literal meaning of the words. Oh, I mean, like doing what you didn't do in Con Law 1, like opening the text of the U.S. Constitution and reading it and seeing what it says. Huh, all right. Well, that's just one SCOTUS option, right? Some SCOTUS judges claim to do that. Another one they point out is originalist. Here, these judges, according to the commentator I'm quoting from, find meaning in the intent of the framers, those founding fathers that are often talked about, those drafters. Another thing or way quoted here is called interpretivist. Interpretivist. What are we talking about there? Our commentators tell us that's treating the Constitution as a living document. Ooh, a document that's alive. Whoa. Treating the Constitution as a living document that must be interpreted to conform to the immediate needs of modern society. Wow. The immediate needs of modern society. You know, words have power, right? It's hard to come out and say, I object to the immediate needs of modern society, right? Hard to say that, right? So let's take a quick look at interpretivist or living constitution from another perspective right quick. And of course, if you've been educated here in the U.S., this is not the first time you've heard of the living constitution, right? I know that because even my young son, who's now 11, but a couple of years ago, he was indoctrinated, educated to the fact that there's a living constitution, right? He came home. He said, Daddy, we studied the Constitution today. Because, sometimes I write things about constitutions. That's great, Patrick. That's great. Yeah, I learned it's a living document. That's great. In his age, you know how education is. Memorize, repeat. Memorize, repeat. He doesn't do what I hope a law student does. Hear, analyze. Hear, analyze. He's memorize, repeat. He's young, right? So I said, well, that's great, Patrick. What's that mean? Living document. And he just stared at me, So I study constitutions. I figured this is a teachable moment. This is my son, right? So I said, well, Patrick, we're having broccoli for dinner tonight. He didn't like broccoli back then. He was sad. But you know what we could do, Patrick? I said, we could have brownie moose tracks for dinner. The local supermarket has its own brand of ice cream. One of the flavors is brownie moose tracks. Patrick loves brownie moose tracks. Well, he smiled, but immediately he doubted me. He knows Dad better than I. He's not going to get a bowl of brownie moose tracks for dinner. I said, well, hey, Patrick, here's what we'll do. Take a piece of paper out, which I did. We'll write it down. Patrick gets brownie moose tracks for dinner, which we did. We'll both sign it. He was so happy to sign that. There it was on the table as I went into the kitchen. I came back with a big bowl for Patrick. Big bowl of steaming broccoli. Dad, we signed it. We did, I said to Patrick. But what we signed was a living document. It has to conform to the needs of modern society. Patrick, you need your vegetables. Dig in, buddy. So there you go. There's that concept. A living document, right? You've got lots of pieces of paper in your desk, in your book bag, at your house, in your office. You ever notice any of them spring to life, run around? Do you have to feed them, water them, take them for a walk, potty train them? Are there such a thing as a living document? So here's that legal fiction then, a living document. How does a living document work? Well, according to these beautiful words, it's interpreted to conform to the immediate needs of modern society. Stated somewhat differently, those with power can just do whatever they want, point to the document, and whether it's there or not, say that that's the basis for their opinion. That's the living document. That's a frightening thing. And I know as I point that out as frightening, in the back of your minds, you're thinking about some of the beautiful, some of the important, some of the noble, some of the essential human rights that we have as human beings that arose because of this interpretivist method of interpreting the Constitution. You're thinking of some of these rights. Some of the rights you're thinking of, I agree with you. We need them. They're beautiful. We should have them. But allow me to respectfully point out that if the sole source of these rights is this legal fiction of a living document, then the basis for those rights is a tenuous basis indeed. Because just as those in power decided to abuse their power and pretend these rights existed when they didn't, those are human beings. They may be appointed for life. But every life will end, and another human being will take their place. And then what becomes of these tenuous rights? Through this interpretivist or living constitution theory, are we a land of laws or are we a land of men? Are we a land of statutes or are we a land of women? Are we a land of rule of law or are we a land of rule of people? And which one do you want to be the basis of your fundamental human rights? Do you want that to be based upon rule of law? Or do you want it to be based upon the whims of judges who come and go and see the world differently and, like me, are fallen creatures? That's what you've got to decide. And that's an important issue that arises not just with the Supreme Court of the United States, but with state high courts. If we're going to give state high courts the same power that we give SCOTUS to be the final arbiters of the text of a constitution. Here it will be a subnational constitution. But that's no consolation if it's the subnational constitution that has wronged you or your client or your family or your loved ones or the people you represent as an attorney. so it can be equally as important. And that's something to think about, isn't it? Now, what do the non-lawyers think? I addressed that in the beginning of chapter 2. It says here that a particular survey said that half the public say the decisions of the U.S. Supreme Court should be based on its understanding of what the Constitution means in current times, while roughly as many say decisions should be based on what the Constitution meant as it was originally written. We live in a nation that's divided on many opinions, and this appears to be one of the opinions the nation is divided upon. I go to Westlaw regularly to do legal research, and there's that homepage that I can't avoid because it's the first thing that pops up, and there's certain things on there. One thing that's been on there for many, many months now is their tribute to Ruth Bader Ginsburg. Ruth Bader Ginsburg was a folk hero, right? And this is true regardless of your politics, regardless of which side of the aisle you're on. You might say that it's the liberal or the Democrat or the left that she's a folk hero for. And I would point out that just a few days ago, President Donald Trump said that her statue should be among the garden of statues that he was planning on building a tribute to, along with at least 2 Catholic saints that he named on that same list. So whether you're on the right or Republican or the left or the liberal, whatever you are, Ruth Bader Ginsburg is apparently a national treasure. I never met the woman herself. I have nothing personally against her. But perhaps for some, not for all, but for some, one of the reasons she's a national treasure is because she takes this interpretivist view. She'll find the right outcome no matter what it takes, no matter how you've got to interpret or reinterpret or misinterpret a constitution or a statute. And we could say, I hope we don't, we could say that the ends justify the means. We've got to have justice. So if that means I tear up a statute and forget what it says, then so be it, we get justice. But is that the kind of legal system that we want for our country? Because if it is, then our human rights become tenuous. You know, there are those who criticize the current system for confirming a U.S. Supreme Court justice. Too political, they say. But if you think like those in this survey quoted in the book think, if you think like that the decisions of the U.S. Supreme Court are a political decision, then of course you want the right politician for the job, right? So we have to ask ourselves, when we're looking for a judge, well, we're looking for like what we had in our last class, where we had an impartial scorekeeper. I don't know what you were thinking. I was yelling, go State, go State. I was hoping State would at least score 1 point before the game was over, but it was a blowout. State scored 0. Why not be a fan of State and say, I'm giving State 9 points? You know, because that's, we got to win. State's got to win. Or should a judge be someone who just calls balls and strikes? And I'm sure you can tell from my criticism where I stand. I believe a judge should be someone who just calls balls and strikes. I believe in judicial restraint. I believe that a judge might not personally have preferred that outcome if that judge were an elected official who was elected to enact and create laws on behalf of the people. But that doesn't matter, in my opinion, because the judge isn't an elected official who's elected for the purpose of creating laws and enacting laws for the people. A judge is a judge because the judge is supposed to be that justice is blind. The judge is supposed to blindly administer justice. The judge is supposed to say, here's the law, whether I like it or not. Here's the proper interpretation of facts, whether I like them or not. When you apply these facts to that law, you must reach this outcome. I don't know about you, but what if you were the litigant? Would you like to have a judge who's simply going to call balls and strikes? Or would you like to have a judge with an agenda? I was at the gas station earlier this week. I went into the convenience store. It's the one right down the road on Lee Road from my office. So I've seen the man, I don't know how many times over the past 14 years. And I knew he had a suit. And he settled it because his attorneys told them about how this judge always rules against. Is that true about this judge? I don't know. But in that one litigant's mind, he had to settle because he didn't want to face that judge. Is that the legal system that we want? Your hands up. Yes.
So even as an originalist or textualist, isn't it still kind of impossible, especially if you hold the belief that all humans are flawed? We as humans would make decisions according to our beliefs or our hidden agenda. Even if we didn't have like an outward agenda, we would still make decisions based on that. It would be near impossible for somebody to just make decisions without anything else
Yeah.
involved.
Yeah. Human nature is what it is. And you've gone one step further with your question. You're looking at human nature and you're looking at if a flawed human wants to be impartial, can a flawed human ever get there? And if we're all flawed humans, then can any of us ever get there? And that is a question that society has asked itself. We ask ourselves often, and lately, whether there is systemic justice or whether there's systemic injustice. There are those who allege that there's systemic racism. And I hope they're wrong. And where they're right, we need to change that system and those systems because we can't tolerate systemic racism. We can't tolerate systemic injustice. If it exists and where it exists, it's got to go. But your question is deeper than that. Can we ever get to a point where the system is impartial and unbiased as we want it to be? And I guess I have to acknowledge that no earthly system of justice will ever be perfect. But that doesn't excuse us from constantly fighting the good fight to perfect the system of earthly justice. That's no excuse for not trying to get it right. With that said, we always take a 10-minute break somewhere within this 2 hours. Let's take a 10-minute break. Let's move off of theory. Let's get to those 8 points that we talk about, 8 points in this chapter. And we'll talk about those, and they too will help to empower you to perhaps constrain a judge when that judge or court interprets a state constitution. Yet again, I want to empower you. I want you to be able to face a system where a state's high court might be infallible because it's final, but yet to be able to control the outcome of that state high court. So let's take 10 minutes. It's 6:42 on that clock. I don't know if that clock's right or not, but we'll come back 10 minutes from now. Whenever that is, it's 6:52 on that clock. It'll be 10 minutes from now. I'll see you then, okay? All right.
The water fountain still turned off?
No.
Yeah, it was off.
Yeah, those have been off for like a year.
I don't know if I want to drink the water that we
Yeah,
said.
it's first time I think.
Yeah.
Exactly. It's like it's the first time. It's like take 10 minutes. Like,
Can I go long or short?
no, you're fine. No, I just.
I'm not drinking. I'm just saying.
You
Not
said
Lord.
10, so I'm like, oh, getting up and then, oh, you're still never. I was
All
ready for the 5 minutes. The 10 minutes.
You realize that feeling in the morning. Yeah. When the dish was closed. And yeah.
And this is part of the constitutional law that always frustrates me on my.
Professor McGillen, just to follow up, I think the syllabus said the final would have an essay. Is it multiple choice or essay? I thought in class you said
Did the
multiple
syllabus
choice.
say the final is an essay?
I'll double check.
I hope not.
Yeah, I just want
Would
to,
you like to amend the syllabus?
it's fine. Well, in class, I think you said it was multiple choice. That's why I just want to
Well,
clarify.
my goal was the essay was something you handed in at that last class, then the essay
address subsidiarity.
Yes.
So the goal wasn't to have an essay as part of that finding.
Okay.
I guess I gotta do what the syllabus
No, no, no,
says,
no,
so
no,
it's
please
worth
don't.
checking.
I'll check it myself.
Yeah, yeah.
So for a slightly deeper dive, if you will, as to how do we restrain a SCOTUS judge, there was a great article by someone named Amanda Frost, and she published in the Georgetown Journal of Legal Ethics an article she called Judicial Ethics and Supreme Court Exceptionalism. She scoured, I presume, in a thorough way, looking for ethics restraints that apply to SCOTUS. You can tell from her chosen title, Supreme Court Exceptionalism, that the outcome was that the Supreme Court of the United States justices were an exception to most ethics rules. I guess you could argue for or against that. Maybe that's a good thing, maybe that's a bad thing. She looked at 3 different statutes that govern recusal of federal judges. She found 2 of them don't apply to a SCOTUS judge. Although there are no written rules governing recusal procedures of SCOTUS judges, she notes, the longstanding practice has been for each justice to decide for him or herself whether to grant the motion to recuse him or her. Okay. Then she looked at the Federal Ethics and Government Act in 1978. She found that that one applies to SCOTUS, but it didn't require much. She mentions how you have to file annual reports where you publicly disclose aspects of your finances. She didn't mention, however, any punishment or repercussions for what was on the reports, just a requirement to file. She looked at the Ethics Reform Act of 1989. She found that they did apply to SCOTUS. At least that one talked about some limits on outside earned income and gifts for federal judges and federal officials. But it doesn't prohibit everything. For example, outside employment, teaching, standing here like I am after work, after a long day of practicing law. That's allowed. She looked at the Judicial Conduct and Disability Act. That was from 1980. That didn't apply to SCOTUS. She looked at the Code of Conduct for United States Judges. It's not a federal statute. It's an ethical guideline adopted by the Judicial Conference, but it doesn't apply. It doesn't apply to SCOTUS. So they're exempt from that. She also talked about how a few critics, including the Supreme Court justices themselves, have raised constitutional concerns, stating that perhaps you could never apply a code of ethics to them. So that's the bottom line there from her article. Exceptionalism, they're an exception. I guess we have to count on Supreme Court of the United States judges to be principled, And I would challenge all of us to be principled. There's a temptation to say that there isn't truth. But the truth is that there is truth. There are things that are true. And on the other side of the coin, there are things that are false. And recognizing that is the path toward being principled. They say sometimes if you don't stand for something, you'll fall for anything. And all these cliches are leading to a conclusion. Be principled. With great power comes great responsibility. That's both a biblical quote and a quote from Spider-Man comic issue #1. So whether it was the son of man or the uncle of Spider-Man who said it, either way, it's true, right? So we move on from there. We talk about how can I empower you to constrain state court judges who, through a proper implementation of the lessons of Michigan versus Long, might be infallible because they're final, right? How can I empower you as a lawyer to affect that outcome? And one thing we have are standards of review and levels of scrutiny. And I think none of this is new to you. To the extent that you heard it before and didn't understand it, I hope I helped to shed some light on it. But of course, I hope that none of it is new. Standard of review talks about after there's been an evidentiary hearing or a trial, after there's been a fact-finding adjudication or some other appealable order, what then does the appellate court do with that order? Standards of review talk about how or whether you win your appeal. And two that I highlight in the text are opposite ends of the same coin. There is the de novo review, and there is the competent substantial evidence review. Is this news to anyone? Anybody here never heard of de novo or competent substantial evidence? Okay, so then you understand then de novo, I don't speak Latin, but looks Latin. Novo looks like new, right? And that helps me remember that a de novo review means that the opinion below is not binding upon the appellate court. The appellate court will start anew. They'll start fresh. They'll reach their own conclusion. And the lower court's opinion or order or adjudication will, of course, have some persuasive effect, but it does not have a binding effect because a de novo review powers the appellate court to reach its own conclusion. A competent substantial evidence review is quite different. Here, the appellate court looks only to see whether there was evidence that was competent and arguably substantial, but let's not put too much emphasis on that word. In a competent substantial evidence review, if there was something admitted into evidence that was either properly admitted or stipulated into evidence or failed to meet with an objection and therefore became evidence, if there's something in the record which could be interpreted to support that fact finding, then the appellate court will leave it alone on a competent substantial evidence review. To help illustrate how that works, allow me to reach out for hyperbole, for an exaggeration. Imagine a 12-day trial. The first 11 and a half days were the prosecution offering the world's most renowned experts who all testified that the earth is round, the sky is made out of air, and the ocean is made out of water. Expert after expert, day after day, for 11 and a half days, testified as such. But on the last day, when the defense finally got its case in chief, they offered an expert who testified that the earth could be flat in certain circumstances, that there are skies made out of water in certain places, and that there are oceans made out of air. So the trial court entered an order stating that in most cases, the earth is round, the sky is made out of air, and the ocean is made out of water. Would that holding survive a competent substantial evidence review? And the answer is yes, assuming that one cockamamie expert testimony got admitted into evidence. So my hyperbole is trying to illustrate the low level of review that we see in a competent substantial evidence or CSE review. There, we're only parsing the record on appeal long enough to find if there was something that got into evidence that would support, in other words, would be competent in support of that fact. Don't put too much weight in substantial, which is what I was trying to illustrate with my hyperbole. This is not a reweighing of the evidence to find out who had more evidence or who was more persuasive. A CSE review is not about what evidence is more persuasive. You'll see appellate courts on opinions applying a CSE review correctly stating that in the first instance, we might not have been persuaded by this, but we defer to the trial judge's better viewpoint, better position or right to find that this itty-bitty, teensy-weensy but competent evidence was more persuasive than all the other. This is not a greater weight of the evidence review. No, 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 no. We're not weighing the evidence on appeal on a competent substantial evidence review. So this is one way that might help restrain what a court can do, that you as a litigant can be empowered to use. Let's take a look at our notes and questions to consider. First one, Considering the greater deference given on appeal to findings of fact versus conclusions of law, de novo. Findings of fact, competent substantial evidence. Considering the greater deference given on appeal to findings of fact versus conclusions of law, just how important are the trial level proceedings in a typical constitutional law claim? The answer is that they are of utmost importance when it comes to determining the factual issues, the factual background, and the facts of the case. The facts and fact-finding of the trial judge are subjected to a competent substantial evidence review and never to a de novo review in almost all instances. That makes the trial court's fact-finding of utmost importance. You might have a client that you honestly believe is a victim of a civil rights violation. You might honestly believe his testimony and the testimony of 8 eyewitnesses that an unprovoked police officer assaulted your client. But what if the trial court believes and the jury believes the testimony of the officer who says, I was acting in self-defense? Assuming that's what the jury and the trial court include in their judgment, you've got a tough case on appeal, do you not? Because it's not going to be sufficient to say the greater weight of the evidence was, because that's not the standard of review. Competent substantial evidence was the standard. Also included in note 1 was this question: if at the trial level the judge or jury accepts disputed testimony that makes proving the constitutional violation more difficult, what effect will this have upon the constitutional law case as it proceeds up the appeal? And as you climb the appellate ladder, the standard of review does not get broader, it gets more narrow. For the most part, generally speaking, you are stuck with the fact finding as it was made at that lowest level, the trial level. So let's not discard or think lowly of trial work, not even in a constitutional law class, because the trial has consequences and it makes a difference. Note 2, if a Florida state trial court misinterprets Florida's constitution or misinterprets the law that allegedly violates the constitution, what standard of review applies on appeal to a Florida appellate court? How onerous is that standard of review? The standard of review that would apply would be de novo. How onerous is it? The trial court's opinion on the conclusions of law are just another opinion to the appellate court. And of course, judges being humans may have great respect for that particular trial judge, but with any luck, they'll also have great respect for you as an excellent litigator. And never underestimate your opposing counsel. Most likely, the judge will also have great respect for opposing counsel. So there'll be 3 opinions that essentially on a de novo review have almost equal weight, but the ultimate weight is the law itself, because the appellate court will be interpreting that law afresh, anew, de novo. So that's the answer to the notes and questions to consider. We also see some imposition of judicial restraint based upon those levels of constitutional scrutiny. You remember those? My gosh, you certainly know these because they certainly came up in your federal con law class. We've got the rational basis, we've got the intermediate, we've got the strict scrutiny. Which one is most favorable to the government? Say you're the government lawyer, you're representing the government, and just say you got your choice. That's not how it works, but you've got your choice. If you're the government, which one are you going to choose? Rational basis. On the flip side, you're representing the individual. And again, it's not how it works, but say you got your choice, you're going to choose strict scrutiny, right? And I liked a lot Professor Randall Kelso, who I never met, but we traded emails. So if you're listening, Professor Kelso, hi. I traded emails and he gave me permission to quote this part from his law review article because I thought it was awesome. You know, you spend all this time learning what these standards of review, what these levels of constitutional scrutiny are, but the way he phrased them is, I think, is fresh. I think it's helpful. I think it's worth reading, and that's why I'm flipping frantically through here trying to find them for you. Okay. Professor Kelso, where's your article? I really liked what he wrote. All right. Here we go. If you've got the printed versions up, bottom of page 32. So he says here, the first inquiry is what governmental interests support a statute's constitutionality. So depending on the standard of review, the government interest must be legitimate or permissible, or it's got to be important, substantial, or significant, or it's got to be compelling or overriding. And we know which ones he's talking about, right? Legitimate or permissible, that's rational basis, right? A little bit higher up the ladder or more stringent up the ladder is that important, substantial, or significant. That's the immediate scrutiny, right? Or at the height of the ladder, it's got to be compelling or overriding. That's strict scrutiny, right? I like how he kind of breaks it down. So that's the first inquiry. And the second inquiry, Professor Kelso talks about, concerns the relationship between the statute's means and how it advances the government's ends. Interesting. Depending on the standard of review, the statute must have a rational relationship, clear what he's talking about there, right? It must have a substantial relationship, or it must have a direct relationship. And I like that. That's a nice place to be able to draw the line between intermediate scrutiny and strict scrutiny, which may not always be a clear line in a student's mind. What he's talking about there is to draw that line. You're talking about either a substantial relationship or a direct relationship. I like that. I like what he's doing here. The third inquiry, says Professor Kelso, focuses on the burdens imposed by the statute's means. Depending on standard review, the statute's burden must not be irrational. So that's all you need here, not an irrational burden. Or substantially more burdensome than necessary, or it must be the least restrictive burden. You remember that language, right? From the strict scrutiny. And the three main standards of review track the responses to these three questions. I love how he broke that down. So you can break it down that way, or you could break it down a different way. That's why I gave you Norman versus State from the Supreme Court of Florida, 2017. State con law breaks these constitutional scrutiny things down and defines them exactly as they were broken down and defined under the U.S. Constitution. So no differences here. So a compelling state interest that accomplishes its goal through the least intrusive means. That's what's meant by strict scrutiny. Substantially related to an important government objective. That's what's meant by intermediate scrutiny. And for the rational basis, whether the legislation is a legitimate goal within the state's police power, and whether the legislature's means chosen bears a rational relationship to that legitimate goal. That's all that's required here under the rational basis. And that's the takeaway from Norman versus State, which I boiled down to 2/3 of a page in your textbook. Am I overburdening you when it comes to reading the case law precedent? 2/3 of a page, that's enough? Okay, there you go. Notes and questions to consider about Norman versus State. Note 1, who bears the burden of proof under each level of scrutiny? I like that. Do you know that? What's a burden of proof? Burden of proof is everything to the litigator. Everything. I'm your friendly neighborhood bar grievance defense attorney. I defend my fellow lawyers, members of the Florida bar or the DC bar or both, against bar grievances and ethics complaints. And whether I'm in Florida or DC, it is the bar that bears the burden of proof. And this is critical, especially under rules and laws that I have to navigate. Things such as statutes of limitations of 6 years. 6 years that only begin once the bar obtains actual knowledge of the event. So the event might have happened 8, 10, 12, 14 years ago, They find out about it today, they've got another 6 years to bring the complaint. And I got to defend against that? Thank God the state, the bar, has the burden of proof in my line of work. The burden of proof means everything. The burden of proof means two people go to court, and they slug it out, and neither one proved their case. It's the one who had the burden of proof that leaves the loser, right? If you didn't have a burden of proof and you proved nothing, you still walk out of court the winner if you didn't have the burden of proof. The burden of proof means everything. So who has the burden of proof? Who has the burden of proof for strict scrutiny? The government. Who has the burden of proof for intermediate scrutiny? The government. Who has the burden of proof for rational basis? The individual, not the government. Not the government burden of proof. Government burden of proof. Government burden of proof. And that can mean everything in a given case. Back to Norman versus State, back to our notes and questions to consider. Note 2. In certain circumstances, would the outcome of a constitutional litigation turn on what level of scrutiny applies? Why or why not? Oh, you got to understand that one. Come on now. Compare the flip sides of the coin, strict scrutiny to rational basis. Strict scrutiny, compelling government interest, least intrusive means of advancing that compelling government interest, burden of proof on the government to prove all those things. On the other side of the coin, rational basis, it's just got to be something permissible and in less than irrational way of advancing a permissible goal. Burden on the challenger. So the answer is the outcome of the constitutional litigation often turns on what level of scrutiny applies. Often, that's the answer to who's going to win. More times than not, if I can get strict scrutiny, who's going to win? Not the government. More often than not, if I can get rational basis, who's going to win? The government, right? So those are the answers to the notes and questions to consider for Norman versus State. And with that, what we looked at is two ways that can restrain a judge, a court, that can empower you, the lawyer, to get the outcome you want in constitutional litigation, but is the canons of construction where I think I give you the most power. Let me introduce them by posing this question. Assuming you agree that statutes and rules of judicial ethics leave judges with sufficient leeway to interpret a constitution in a partisan fashion without losing their jobs or suffering discipline. If that's true, what other potential source of judicial restraint might exist in state constitutional law? The answer is that when it comes to SCOTUS, when it comes to the federal judiciary, when it comes to the Supreme Court of the United States, it's within the Supreme Court justices' own personal ethics to determine whether they're an interpretivist, or they're an originalist, or they're a textualist, or they're whatever other ist you want to throw in there. Must that be true on the subnational level? Must it be true under a state constitution that judges have no further restraint other than to choose their own ist, to adopt their own ism? And the answer is, thanks to Michigan versus Long, courts can, on a subnational level, they don't have to, but they can adopt rulings. They can enact requirements so that judges have more than just ethics to guide them. They might have rules or canons to tell them how to interpret or construct the state constitution. there can be, on a state-by-state level, canons of construction, rules of interpretation. In Florida, we have at least 8 rules of interpretation, which I will refer to as our canons of construction. What I will do is I'll put them up on the big board. We'll talk about all 8. We'll learn how to use them. Or, God forbid, how to abuse them, so that you are empowered to get an outcome that's based on rule of law instead of just the favorite personal outcome of whatever judge or justice you happen to be in front of. Sound good? Let's talk about the big 8. Let's put them on the board. Let's learn what they mean. Let's learn how to use them. Number 1, obey the clear and unambiguous language that we find in Florida's Constitution. Now, here on the big board, we're not talking about the U.S. Constitution. Here on the big board, we're not talking about every state's constitution. Here on the big board, we're talking about just one constitution, and that's Florida's Constitution, the Constitution of the state of Florida as it exists today, and the case law interpreting it. That's where these 8 canons of construction that we're going to talk about for the next 45 minutes come from. So don't leave this lecture thinking, aha, I can argue these to SCOTUS. You can't. If you're heading off to Georgia, the Carolinas, Illinois, New York, California, wherever it is you're going to practice law, you might want to check to see if any of these are among the canons of construction of that state, but that's not what I'm telling you. What I'm telling you is that they're part of the canons of construction of the Constitution of the state of Florida. So here in Florida, first canon we're going to talk about, obey the clear and unambiguous language. And what do I mean by that? First, begin with the actual language of the constitutional provision. Do what you didn't do in Con Law 1. And go to flaconstitution.com. You see the hyperlink to the text of the Constitution of the state of Florida. What a novel idea. You look at the text of the Constitution to determine what the Constitution says. What? Yeah. That's the first canon of construction for Florida's Constitution. When that constitutional language in Florida's Constitution prescribes a manner of doing an act, then the manner described there is exclusive, and the legislature may not enact a statute that would defeat the purpose of the constitutional provision. Note the caveats. Hey, it's law school. There's always exceptions to the rule, right? Note the caveats. And as you read the Constitution of the state of Florida, you'll look and you'll see that some language expresses a general principle. The freedom of speech shall not be abridged is a paraphrase of the general principle that you find there. In other places, you see things such as the size of a cage of a pregnant pig must not be less than this many inches by that many inches by that many inches. And if you think I'm making that up, go ahead and pull up the Constitution of the state of Florida. It doesn't explicitly address any rights for pregnant people, but it does address constitutional rights of pregnant pigs. So, for better or for worse. Now, comparing and contrasting those two paraphrased parts of the Constitution, what you see is one spells out a general principle and probably needs an enabling statute, enabling, enabling legislation. This is legislation that gives us the details, that gives us an enforceable cause of action, a cause of action being a right to sue, something to sue for, and spells out duties and responsibilities in an enabling statute. But some of the language of a state constitution does not need an enabling statute for reasons including the fact that it gives us detail about how a thing is to be done. So if that's true, or in other words, when it prescribes a manner of doing an act, then that's the way you do it. And you don't do it another way. And you don't have the right, even as the Florida legislature, to enact a law doing it another way. That's what we're talking about when I say obey the clear and unambiguous language. So you got to make sure the language is clear and unambiguous first, right? When the Constitution of the state of Florida expressly provides a manner of doing a thing, then it impliedly forbids it being done in a substantially different manner. That's our first rule, and it's illustrated by the case I gave you, City of Jacksonville versus Continental Can. Let's get to that page. Here, what is the takeaway from City of Jacksonville versus Continental Can? It talks about, how do we know? How do we know whether it's clear and unambiguous? What's the legal standard? What do I apply? 3 takeaways from Continental Can. First, if it's clear and unambiguous, then there's truly no construction to be done. There's no interpretation needed. If it's truly clear and unambiguous, then you just do what it says. Second takeaway from Continental Can. Use the usual and obvious definition. So when we see language in the Constitution, what definition do we give that language? We give it the usual and obvious definition. Okay, McGinley, but which one's the usual and obvious definition? Well, I've got a definition for usual and obvious. The usual and obvious definition is the one that is natural and popular. Okay? So maybe in I'm making up a date, 20, the Constitution talked about tweets. In 1920, would this hypothetical constitutional language have been referring to communication via the app called Twitter that was invented circa 2015? No. So we're talking about the natural and popular, the usual and obvious language at the time it was written. Depart only from this usual and obvious, this natural and popular definition, if it's absolutely certain that it's not clear and it's not ambiguous, which kind of puts us back in a circle. We're obeying the clear and unambiguous language. So if it wasn't clear or it was ambiguous, then obviously we're not doing that. So that's the first of our 8 canons that we see up on the big board. Let's not stop there. Presume a law or action is constitutional. That's powerful, right? Presume the law passed by Florida's legislature, or as we'll learn later in the semester, laws can come from other places, right? They can come from the Florida Administrative Code, right? They can come from a county. They can come from a city. They can come from a district. Southwest Florida Water Management District, just pulling one out of a hat. There are many sources of state law. This canon of construction, presume the law or action was constitutional, means in those instances where the court is not applying strict scrutiny, remember that standard of review can be the difference between winning or losing. In those instances where the court's not applying strict scrutiny, the result is that the law or government action is presumed constitutional unless and until proven otherwise. So it's cloaked in a presumption of constitutionality unless strict scrutiny applies. With certain rare and narrow exceptions, such as a prior restraint upon free speech of a political nature, a duly enacted law is presumed to be constitutional. And the Supreme Court of the state of Florida recognizes that one asserting the unconstitutionality of the act has the burden of demonstrating clearly that the act is invalid. So this goes to burden of proof, and we talked about how powerful a concept that is when it comes to litigating a constitutional claim. So a finding of unconstitutionality is disfavored is one way to view the rule I just gave you. All doubts are resolved in favor of constitutionality if this rule applies. It must be clearly unconstitutional beyond a reasonable doubt is another way to phrase the effect of this second constitutional canon. Let's look at a third canon. Consider stare decisis. We mentioned that earlier in our lecture, and I said I would get back to it, so I'm keeping that promise. And of course, we're all familiar with stare decisis, right? We all recognize stare decisis. It was one of Vincent van Gogh's greatest paint. Oh, shoot. I always mix Starry Night and stare decisis up. Sorry about that. No, this is Starry Night, which I think is one of Vincent van Gogh's greatest paintings. I like it. Anyway, but that's Starry Night. We're talking about stare decisis. In Florida, as elsewhere, stare decisis refers to the acknowledgement of prior precedent and the following of that precedent. When the issues underlying that precedent arise again in later litigation. What's good for one is good for another. What's good for the geese is good for the gander. If I've got the same or substantially similar facts and I'm applying the same or substantially similar law, you would expect the same or substantially similar outcome, right? There are entire industries that are based upon such an outcome. If you're an insurance company, obliging yourself to pay the debts of another, you'd like to know what the tort law is in your state, right? You're going to base your premiums on the actuarial expectations of what you understand the tort law to be. You don't want to live in an environment where anything goes and you never know what the outcome will be in a particular litigation. So the insurance industry is just one of many examples of folks wanting to know what their rights are without having to go litigate them. Be a nice thing to know, right? Say you're running a business. You want to comply with all state laws and regulations. It'd be nice to know what it takes to comply, right? Stare decisis contributes to that. There's two types of stare decisis. There's a rule stare decisis and a result stare decisis. So this rule stare decisis results in requiring a particular rule or statute has to apply to a given case. Our result stare decisis means results in requiring the outcome of today's case being the same outcome as in a prior case. Maybe I'm splitting hairs there, but what we sometimes find, particularly in constitutional law, is courts overruling prior precedent, right? As we work our way up the litigation ladder and we get to either a state's highest court or the nation's highest court, we find that court empowered to overrule its own precedent. So I think it's noteworthy to point out that there's two types of stare decisis. Perhaps over time, we'll find different rules applied to the different types of stare decisis. I don't see that in the case law of the state of Florida at this time, but I'm suspecting that as stare decisis evolves, perhaps the standards might be different for the two types. Let's take a lesson from Hague versus State. Or is that Hague versus State? I don't really know inmate Hague or Hague, so I don't know how to pronounce it. But the basis of the case here was habeas corpus, which in Florida, the procedures appear in Rule 3.850 of the Florida Rules of Criminal Procedure. So a 3850 motion, as a practitioner might sometimes say in Florida, is trying to invoke the prisoner's right of habeas corpus. Habeas corpus, as you already know, is an attempt to have a get out of jail card, right? Habeas corpus is an allegation that someone has denied you your freedom that lacks the power and authority to do that. Does Rule 3.850, which sets a deadline for filing post-conviction motions, prevent consideration of a motion when the incarcerated petitioner did everything the incarcerated person could do to get that motion to the courts? They wrote it, they signed it, it was facially sufficient, it was put in an envelope, it was addressed to the right person, they put a stamp on it. But remember, they're incarcerated, so there's one step they can't do. They can't go to the post office, right? They rely upon their jailers to bring it to the post office. And I don't know these particular jailers, but possibly, maybe the jailers might drag their feet a little bit before bringing it to the post office, or allegedly did that. So can we deny habeas corpus, which had a deadline under 3850, simply because the jailers didn't put it in the mail on time? And what we found was we didn't have an exception for that in the rule. And we had case law precedent that was unfavorable to the inmate. What Hague versus State was, it's an example of overruling that prior precedent. Under federal law and federal law only, the habeas corpus writ had a mailbox rule. Under federal law and federal law only, when the inmate handed it to the jailer, that was considered the date of mailing. That wasn't true under state law. That didn't appear in Rule 3.850 of the Florida Rules of Criminal Procedure. That was contrary to prior precedent. Hague versus State overrules all of it and adopts a mailbox rule. Notes and questions to consider. Question 1. What are Florida's exceptions to stare decisis as defined in Hague versus State, or Hague versus State? Mr. or Miss, I don't know which, Hague or Hague. If I'm mispronouncing your name, I apologize. What are the exceptions? I would highlight the next to last paragraph in the excerpt from Hague versus State that I gave you, the paragraph that begins with the word that I personally try to avoid in my own writing, moreover. Moreover. I don't know why I don't like moreover. Yeah, y'all use moreover? Moreover. I don't use moreover. Anyway, moreover, as we have said before, stare decisis is not an ironclad and unwavering rule that the present always must bend to the voice of the past, however outmoded or meaningless that voice may have become. Except for that first word, moreover. It's pretty artfully written stuff, right? It goes on. It is a rule that precedent must be followed, except when departure is necessary to vindicate other principles of law or to remedy continued injustice. We find the guarantees embodied in Florida's Declaration of Rights are best vindicated by overruling the contrary precedent noted above. Hey, McGinley, that sounds like a beautiful speech, but doesn't really sound like a rule of law. And sorry, but it's the best we got. It's the best we've got. Best we've got here in Florida as a rule of law for stare decisis. Notes and questions to consider. Number 2, to what extent was the departure from stare decisis in Hague versus State a result of prior precedent being unconstitutional? To what extent is it a result of a reinterpretation of the Florida's Constitution's right of habeas corpus? And I guess that question is one of opinion, is it not? Maybe I've given you enough of an excerpt of Hague versus State to reach an opinion, or maybe I haven't. You might argue the Declaration of Rights of Florida's Constitution was always offended and always violated by this prior case law precedent and this Rule 3.850 that reflected the state of prior case law precedent. We can't simply ignore the ongoing constitutional violation based on stare decisis, you might argue. Or you might argue otherwise. You might argue, whose place is it to enact laws? Whose job is it to draft rules of court, to enact statutes? We have legislators. We have elected officials who the people, with their power, have elected and appointed to create laws. Should the laws be created by them? Or should a judge say, well, since I've been appointed to blindly follow the law, I'm going to rewrite it from time to time. To me, that's offensive. To others, that's applaudable. You have to reach your own opinion on that. So back to the big board, we've got obey the clear and unambiguous language. Presume a law or action is unconstitutional. Consider, notice I didn't even put the word apply. Consider stare decisis. Next on the big board, determine the intent of the framers or voters. Ooh, I sound political now, right? It's clearly, if we were talking about the Supreme Court of the United States, which we're not, if we were talking about the U.S. Constitution, which we're not, this would be a political question. A SCOTUS judge would decide what ism they are, right? What ist they are, what ethics or logic they follow. What I'm saying is that need not be true on a subnational constitutional level. Here, under Florida's Constitution, we have binding case law precedent that says that we're supposed to determine the intent of the framers or voters when we interpret the language of our state constitution. For the U.S. Supreme Court, it's a political question. Not so when Florida courts interpret Florida's constitution. Binding case law precedent of the Florida Supreme Court informs lower courts that in construing provisions of the Florida Constitution, the first step is to ascertain and effectuate the intent of the framers and the people. First, give Florida's Constitution's words the meaning suggested by the circumstances leading to the adoption of the constitutional provision the courts are interpreting. Question.
Was it the framers or voters or the framers and?
Yeah, because there's a difference in subnational constitutional law. Excellent question. And you heard the question. Is it the framers or the voters? The framers and the voters? Whose intent are we giving? And that's an excellent question, especially in subnational constitutional law. In 1789, we enacted the U.S. Constitution. And on the most rarest of occasions, we've added an amendment. That's the history of the U.S. Constitution. And that's certainly the opposite of the history of any state's constitution, the Florida Constitution included. Because the Florida Constitution, the current version, is from 1968, which replaced many prior versions. And every year, you won't find a year that's an exception. Every year we amend it. I mean, the number of amendments is astronomical, especially in comparison to the relative few amendments that we've made to the U.S. Constitution. So yeah, it depends on what language we're talking about and where it came from. A given state, such as Florida, we really can't point to a group and say, that's Florida's founding fathers, or there's Florida's framers, right? But on a given piece of language that was added to our Constitution, it has an origin. It has an origin. That origin is whoever's drafting it, putting it forth. Those are the framers. That origin is when people vote for it. Those are the voters. Most important on a subnational level, especially here under Florida's Constitution, is the intent of the voters. The logic under Florida constitutional case law precedent is this. Floridians personally amend Florida's Constitution. We'll study in a later chapter how to amend Florida's Constitution. You'll find, although there are 7 different ways to amend it, they all end the same way. It goes in front of the voters, you and I, and the voters vote yes or no. So the ultimate question becomes, what did the language mean to the ordinary citizen who on that day was standing in the voting booth and voting yes or no on that language? So that's the ultimate question. And for that reason, what we have under this particular determine the intent of the framers or voters is a respect for subsidiarity, a respect for the individual, a respect for the citizen, a respect for the voter. If the voter thought that the language meant X, then we give effect to what the voter thought the language meant. Remember young Patrick, who wanted a bowl of ice cream and got a big steaming bowl of broccoli. That's the opposite of this canon of construction, where we give respect and probably effect to what the voter thought the voter was signing up for when the voter signed the piece of paper that said, today daddy gives me ice cream for dinner. Yes.
That kind of begs the question of what are the voters what's their interpretation?
Yeah.
I mean, really, it's because you have, just in the state alone, we have people with such a diverse background. Some people would think one thing is.
That's true.
one way,
And I
and so,
think,
based off this, it doesn't seem like there's earlier when we were talking about the plain popular language, is
Right.
that still going to be the same here? But would that be regionalized also? Or-
I think my next slides answer your question. Let me do them, and I'll come back to you and make sure your question was answered. So what does it mean? What was the intent of the framers of the voters? Courts may turn to sources such as the documents of the Florida Constitutional Revision Commission and the Florida legislature, which may have been the source of that particular language. If the language comes from an amendment, courts must give effect to the intent of the voters who approved that amendment. I give you 3 different cases here, and it's not the substance of the particular law being analyzed in that case that's the point I'm trying to make. By giving you the 3 cases, the point I'm trying to make is to show you how they determined the intent of the framers of the voters in that case. So let's look at the first case. Let's look at Department of Revenue versus Leon County. That case substantively was answering this question. Can Florida's legislature pass a law keeping 6% of the Constitution's gas tax? That substantive question, can Florida's legislature pass a law keeping 6% of the Constitution's gas tax, isn't my point in including this case. My point was they wanted to know the intent of the framers of the voters and how did they do it. Over here, you see that the parties agreed. Here's my 2-minute warning, which is not literally 2 minutes, but it reminds me that we're wrapping up soon. The parties agreed that the particular language in 1885 prohibited. The issue is whether the 1968 Constitution authorized. And how did they determine whether the 1968 Constitution authorized what the 1885 Constitution prohibited? Quote, the 1968 Constitution as amended cannot be read as abolishing the prohibition and incorporated into the more recent document. Provisions of the Florida Constitution are to be construed so as to effectuate the intent of the framers. The framers of the 1968 Constitution clearly stated that in certain respects, the constitutional scheme was to be changed. There's no clear statement, however, that this particular language has been discarded. So here we have an example of language that was created wholesale when we tore up the 1885 Constitution and enacted the 1968 Constitution. For that reason, we had something akin to founders or framers. So we looked at what they meant. Compare that to this opinion, Gallant versus Stevens, again offered for the procedural, but embodying the following substantive question. Can the Florida legislature authorize counties to create a taxing district without voter approval covering and benefiting the unincorporated area of the county? So substantively, Gallant versus Stevens is asking if the Florida legislature can authorize counties to create this taxing district without voter approval, without the approval of the unincorporated area. Those are the folks that are being affected by it. Substantively, the answer was yes. How did they get to the answer of yes? That's the point of including the case. Here we see the following, quote, the history of the 1966 Constitutional Revision Commission and the Florida legislature supports Appellee's view. It's reasonably clear from the minutes and notes of the Constitution Commission and from the reports of the legislature. So here we went further than just looking at the text and comparing the text. Here we went to a commission that had drafted it. We looked at their notes to see what their intent was. Legislature participated in drafting it. Legislative committees generate reports. We looked at those legislative history. Compare that to the third case I offer you, Graham versus Herodopoulos. Substantively, it was asking this question. Does Florida legislature set the state college tuition rate, or does the constitutionally created Board of Governors set that rate? And the Constitution's been amended since then, so the substantive answer doesn't have a lot of relevance today, and it's not why I included the case. I'm talking about the procedure. How did they go about answering the question? They said the following: because the issue presented in this case involves constitutional construction, we begin with the actual language of the constitutional provision. So they did what you didn't do in federal common law. They opened up the text of the Constitution to start their analysis. Quote goes on, simply put, the language of Article 9, Section 7 is not clear or unambiguous. Okay, remember that on the big board? So we can't apply that rule, they say, because it's not clear and unambiguous. What are they doing here? They're following the canons of construction. It's almost as if they've got the big board in front of them when they try to figure out what the Constitution means, right? So they first turn to the language. They find it's not clear. They find it's not unambiguous. They find it to be ambiguous. Quote, we therefore turn to principles of construction, always endeavoring to construe the constitutional provision in a manner consistent with the intent of the framers of the voters. So they're applying this canon of construction. And how do they apply it? Quote, we review the ballot summary because it's indicative of voter intent. When you stand in the ballot box as a Floridian and you're voting yes or no on a constitutional amendment, you've got a court-approved ballot summary. It's not the exact language of the amendment. It's not the full language, but it's been approved by a court, Supreme Court of Florida, as a fair and accurate ballot summary. We can consider that ballot summary because that's what the voters were staring at. That's what they were voting yes or no on. So what I'm trying to illustrate with these cases is, I believe, an answer to your question. And your question was, how do I know the intent to the framers of the voters? And here are some examples of how Florida courts can go about answering that question. So with just a couple minutes left, allow me to talk fast. But with that said, of course, I'll address questions in our next class. Interpret parts of the Constitution to yield a consistent whole. And that goes hand in hand with this rule, interpret words in the Constitution in pari materia. So here, interpret parts of the Constitution to yield a consistent whole document, and interpret words in a sentence or a paragraph to yield a consistent sentence or paragraph. When a particular interpretation represents the only interpretation consistent with the whole Constitution, then that's the preferred interpretation. Likewise, in pari materia differs slightly. That prior one required the court to look at the entire document. In pari materia says, look at those words in the context of the sentence or paragraph that surround it. So what are these two rules telling us to do? We're going to interpret parts of the same subsection harmoniously as one. In this way, neighboring language serves as a common purpose and achieves a common objective, even if particular words or sentences within that language were enacted at different times. So when it comes to subnational constitutions, they're constantly under amendment. But yet, where you put the language matters, because we're going to interpret those sentences consistent with the surrounding sentences, and we're going to interpret that group of sentences and paragraphs consistent with the document as a whole. Avoid interpretations resulting in superfluous language. And that means simply what it says. Nothing in the Constitution is to be rendered meaningless in its interpretation. A construction of the Constitution that renders superfluous, meaningless, or inoperative any of its provisions should not be adopted. So it's not null and void that you have that language in there. You're supposed to give it a meaning and effect. When a constitutional provision will bear two constructions, choose the one that is consistent with another section of the Florida Constitution. In that way, the purpose of the people in adopting the Constitution should be deduced from the Constitution in its entirety. So if the people add language, part of our canons of construction is to avoid making that language a nullity and instead to interpret and include that language. I'll skip the notes and questions to consider in the interest of time, and I'll add instead the last of our 8 rules. Defer to the legislature's choice among permissible meanings. In certain instances, we're going to defer to the legislature. And the certain instance is this: if a constitutional provision may well have either of several meanings, if the legislature has by statute adopted one, then its action is respected. The ifs are critical here. If there's a right interpretation or wrong interpretation, and they interpreted the wrong interpretation, we give the wrong interpretation no deference. It's those rare instances where there are 2 equally correct ways to interpret the language. If the legislature chose among those 2 equally correct ways, we're going to show the legislature deference. And that's particularly true if the legislature makes its choice contemporaneously with that language being added to the Constitution. This canon is particularly applicable to legislative enactments made contemporaneously with state constitutional provision at issue. A relatively contemporaneous construction by the legislature is strongly presumed to be correct. This does not mean that a law is constitutional simply because the legislature chose to enact it. It means that if by enacting a law, the Florida legislature made a choice between equally permissible meanings of the Florida Constitution, then and only then Florida's courts should show deference. And that, my friends, are 8 canons of construction that can empower you, even in a state where the state's high court properly applies Michigan versus Long to make itself the ultimate final arbiter of the meaning of state law, including the state constitution. With that in mind, we're going to look at chapter 3 next week, but I will begin by taking questions about chapter 2. Until then, may God continue to bless us all. Have a great week, and I'll see you in 7 days. Thank you.
Thank you.
Thank you.